Okay, this is the case of Somerville versus Olympus State University. William Denolf is president. Petitioner. Go ahead.
Mr. Chief Justice, and may it please the Court, my name is Brianna Edelblut, and I, along with my co-counsel, Joseph Voss, will be arguing on behalf of Ms. Andrea Somerville, the petitioner in the case at bar. At this time, I would like to respectfully request 3 minutes for rebuttal.
All right.
I will be addressing the issue of the First Amendment, considering first how the university's policy is on its face unconstitutional because it classifies all areas outside of the free speech zone as a non-public forum, thus giving the university the authority to regulate and silence free speech in these areas. Second, the policy is unconstitutional as applied because it is a content regulation which, according to Widmar versus Vincent, demands strict scrutiny, and the university fails to satisfy either a compelling interest or a narrowly tailored statute. Now, beginning first with the issue of the policy on its face. Your Honors, the university policy in Section 3 states that all areas outside of the free speech zones will be considered a non-public forum. This is the language that the court has used to describe a military base or a prison. However, for a university, in Widmar versus Vincent, citing Police Department versus Mosley, this court held that the streets and sidewalks of a university for its students should be considered analogous to that of a traditional forum. Your Honors, by classifying this as a non-public forum, the university is given the authority to have a much lower standard of review for any discrimination it wishes to place on these areas. If we look to the case of Cornelius versus NAACP, as cited in Roberts versus Harrigan, this court upheld a prohibition on political speech simply because it was occurring in a non-public forum. Additionally, if we look to the case of Schweer versus Gruck, as cited in Roberts versus Harrigan, as well as peri-educators versus peri-local educators, the court held that in a non-public forum, the state need not even have proof of disturbance in order to institute a regulation. This means that Olympus University could silence a student wishing to talk about their religious rights, talk about what they view as race discrimination on the campus, talk about abortion, gay rights. Even if the speech was not in a demonstrative manner, the university, without so much as the justification of disturbance, would be able to regulate that speech.
Counselor, even if we adopt strict scrutiny on this case, hasn't the university demonstrated a compelling interest in preventing disruptive speech, that is, this type of speech with bullhorns and loud demonstrations that disrupt classroom activities during normal classroom hours? Isn't that a compelling interest for the university?
Respectfully, Your Honor, that would not be considered a compelling interest. If we look to the case of Tinker versus Des Moines in 1969, the dissent in that instance attempted to make the same argument. They pointed towards the fact that the students wearing black armbands in a math class completely wrecked the math class, thus disrupting the education.
But that's really a difference between demonstrative and pure speech, isn't it? We're talking about regulating pure speech, but pure speech that by its very nature can be disruptive. A black armband doesn't make any noise, but somebody who's using a bullhorn outside of a classroom can disrupt the educational activities going on inside, right? Isn't that a compelling interest to try to protect the educational process in this case?
Your Honor, whether this is dealing with demonstrative speech or pure speech, in neither instance is a disruption to education considered a compelling interest according to this court.
How about the idea of obstructing traffic or impeding entry into certain administration buildings? Isn't that enough reason?
Respectfully, Your Honor, we see that in the case at bar, Ms. Somerville's protest was not actually to the point of impeding access. The officers simply reported that it was an orderly protest that might potentially impede that access.
But is there a requirement that it reach the level of actual impediment, or isn't it enough that that's a reasonable, foreseeable possibility?
Your Honor, this court has never upheld likelihood to be an actual compelling interest. In the case of Brandenburg versus Ohio, as cited in Texas versus Johnson, there was an instance of individuals in the Ku Klux Klan actually advocating violent, lawless action. But because that action was not considered to be an imminent threat, the court did not uphold it as a compelling interest. Simply the fact that Ms. Somerville's protest may at some point in the future impede access is not an imminent threat of lawless action. That was what was required by this court in order to satisfy a compelling interest.
Is Somerville saying that the university is not able to direct locations where speech can be held.
Respectfully, Your Honor, what the university and what the petitioner contends is that by designating these areas as a free speech zone and classifying all other areas as a non-public speech zone, the university has taken away alternative channels of communication as found in Perry. This court said in Tinker versus Des Moines that if freedom of expression is regulated only to those areas that a benevolent government wishes to set aside as a safe haven for crackpots, then freedom of expression does not truly exist. In this instance, if the university simply sets aside these areas as the only areas that are a designated or open forum and the rest of the university is a non-public forum, then the university is doing exactly what Tinker struck down.
But this is an educational setting. Isn't that different?
Respectfully, Your Honor, in Tinker, we were also dealing with an educational setting. That was in the school district for Des Moines. And in that instance, the state found that in the school setting, it is still imperative that speech be protected. Additionally, the court held that in Healy versus James, as cited in Widmar versus Vincent, where this court found that nowhere is it more vital to protect First Amendment liberties than in the community of America's schools.
These free speech zones are not on the outskirts of campus. They're not off some, beaten path. They're right in the heart of campus where the students have to pass every time they want to eat and every time they want to go to the student building. It seems to me that those would be the most logical places to designate as the free speech zones.
Your Honor, designating the free speech zones to this area is not necessarily the issue. What is at issue is that the streets and the sidewalks elsewhere could potentially be silenced for even just a student communicating one-on-one with another student regarding their views. Because in a non-public forum, according...
And I don't mean to interrupt, but you're suggesting that if I am standing outside my dorm room talking to my roommate, I'm violating the expression policy?
Not that you would be violating the policy as of yet. However, in Spear versus Grock, as cited in Perry Educators, in a non-public forum, the state need not even have a proof of disturbance in order to regulate speech in a non-public forum. This is why non-public forums have traditionally been military bases and prisons, because the standard of review for those areas has a much lower standard. Thus, the university, although its policy as of yet does not regulate the speech in that area, if this court were to uphold the precedent that the rest of a university campus is a non-public forum, it would set the precedent for state universities across the country to be able to regulate the speech of their students. If that regulation is allowed on simply pure speech that is not even disruptive.
But how are they regulating speech? The policy on its face says that it's a non-viewpoint, non-content policy.
Respectfully, Your Honor, even though the policy may state that it intends no such discrimination, that does not automatically make the policy a constitutional policy. On its face, the policy states that all other areas are a non-public forum. And when applied in this instance, we see that this is a content discrimination on the content of ROTC. In Perry Educators versus Perry Local Educators, the court held that in order for something to truly be a time, place, and manner regulation, it must be content neutral. The fact is, this policy is not. The security officer only approached Ms. Somerville because he noted that the subject of her policy was related to ROTC discussion.
Well, when you say it's content restricted, I'm assuming you're talking about the part of the policy which says that they want to maintain a good relationship with, but that's really not restricting the content of the speech, is it? I mean, people can talk pro or anti-ROTC. It's not really restricting the content.
Respectfully, Your Honor, the intent appears to be vague from the language, but Arkansas versus Forbes instructs the court that when the actual language is vague, we look to the intent of those who will be enforcing the policy, since they will determine how it's applied. When we look to that intent, President William Denault stated that the policy was enacted in order to exclude both speech for and against the ROTC. The policy as it will be enforced is a policy that will be enforced as a content regulation.
I think we've been spending a lot of time on the policy itself, and your second point was how it's been applied. Would you briefly address that, because I know your time's about out?
Right now?
Yes, Your Honor. Addressing that point very briefly, as applied in the case of Ms. Somerville, this was a content regulation. On her discussion of ROTC speech, she was only stopped because it was ROTC and only approached because of that. That content regulation demands strict scrutiny, and the university, according to Texas and Tinker, has not satisfied a compelling interest test.
Thank you, Ms. Very good. Thank you. Please.
Mr. Chief Justice, and may it please the Court, my name is Joseph Allman, and I will be continuing arguments for Ms. Andrea Somerville, the petitioner in the case at bar. Ms. Andrea Somerville was entitled to the protections of the Due Process Clause because she possessed a protectable interest in her education that was threatened with expulsion. And she was denied this due process by the university because the university never provided her with an impartial hearing. First, moving to the issue of the protectable interest, Ms. Somerville was threatened with expulsion. If we examine Section 6 of the Student Honor Code, it says that violations of this policy may result in expulsion. Now, Your Honor, the reason that this is significant is that when this court determines due process, it examines what punishment could be granted to an individual, not what punishment is actually granted.
Are you going to say that any policy, even though the punishment is lesser than the maximum, that just because there is a maximum penalty, that comes under your analysis here?
Yes, Your Honor. The reason for that is, take, for example, a criminal court. In a criminal court, if an individual were to be threatened with capital punishment, they would receive that level of trial regardless of whether or not they actually gave capital punishment. And additionally, that's the only reasonable way that this court could go about determining due process, because otherwise every determination of due process could only be made ex post facto. An individual would never know whether or not they were receiving sufficient due process until after the trial had already occurred.
Well, I mean, the hearing that Ms. Somerville had, she was given 14 days to prepare. She was having a chance to present her own witnesses. She had a chance to cross-examine the police officer. I'm having a problem following why that's not due process.
Absolutely, Your Honor. If we actually examine the issue of due process, there are three requirements laid down by this court that are not negotiable. First, in Joint Anti-Fascist Committee versus McGrath, as cited in our record in Goldberg versus Kelly, this court established that there are two requirements of notice and opportunity for a meaningful hearing.
And she had those?
Yes, Your Honor. The second, this court decided in Goldberg versus Kelly, however, an additional requirement that of an impartial adjudicator is essential. It's not optional, it is required. And in the case of Barr, the only standard that would have, or the only review that would have satisfied both notice and hearing was the second review that the board did. However, at this time, they were not an impartial adjudicator.
But you base that solely on the fact that they'd heard or they decided the discipline once before. I mean, can't they still be impartial? They're going to hear the evidence. They're going to hear new evidence.
No, Your Honor. This court based its decision in Armstrong versus Manzo off the fact that the group Armstrong had already been ruled against in that case, and therefore it shifted the burden of proof. It's very analogous to the case at Barr, where Ms. Somerville had a first hearing, just like Armstrong, that she couldn't be present at. But the second hearing, even though they both had the full evidentiary hearing, did not satisfy the requirements of due process because the burden of proof had been shifted at that point.
No, counsel, it seems to me you've jumped to the due process, assuming that she's entitled to due process, but I don't know that you've established she had a liberty or property or life interest. I assume you're not arguing she had a life interest here.
No, Your Honor.
Okay. Are you arguing there was a liberty interest or a property interest involved here?
Well, Your Honor, the main interest that we'd like to contend is that of her education as threatened with expulsion. If we look to Joint Anti-Fascist Refugee Committee versus McGrath, as cited in our record in Goldberg versus Kelly, this court noted that the extent to which procedural due process is afforded to a recipient is influenced by the extent to which he may be condemned to suffer grievous loss.
And I'm not convinced, though, that the mere threat of expulsion is enough to rise to a property interest. Is that the sole basis for your property interest?
No, Your Honor. We can move on to a liberty interest in the free speech rights that were threatened of Ms. Somerville. She was being punished because of her exercising of free speech rights. And this court noted in Waters versus Churchill that simply a challenge to free speech automatically invokes due process. This court also noted that in Carroll versus Princess Anne, as cited in our record in Board of Regents versus Roth, that the mere implication of a free speech claim automatically invokes due process. She had a liberty interest in her free speech rights as well. And also,
isn't she being disciplined here not because of what she was saying, but because she failed to follow the officer's direction to disband because she was impeding access to the campus building?
There are two responses to that, Your Honor. First off, she was being punished because she was speaking on a policy that the college had ruled was against a policy that the college had ruled was in restricting speech. It was because of her speech that she was actually being punished. Additionally, Your Honor, merely disobeying the security guard. If a security guard is granted illegitimate authority, it is illegitimate authority, and an individual has to force them to comply with that is not acceptable.
So you're kind of arguing a bootstrap argument, because you're going to argue after the fact that the security guard didn't have authority. I mean, the policy had been passed, right? I think the day before, if I recall correctly, and she knew about the policy. Is that up to her to determine whether the security guard had the authority to enforce that, or whether the policy was legitimate or not?
Well, not necessarily, Your Honor. What's significant is that this court does have the authority to determine whether or not this policy was legitimate, and in this case, it infringes upon her free speech rights. Additionally, Your Honor, however, she still required due process because she had the protectable interests of education and a liberty interest. If we actually examine what process is due, she did not receive that. We examined Armstrong versus Manzo already, but we can look to other analogous cases, such as Goldberg versus Kelly, where Goldberg had sanctions imposed on him before he actually got to have a hearing. This court ruled that that was not acceptable due process. And in the case at bar, Ms. Somerville had sanctions imposed upon her first, and then she received a hearing.
Well, except the appeal presumably means that they weren't going to implement those sanctions until after she had the hearing, right?
Perhaps, Your Honor, but what's significant is that they use the term appeal. Appeal is a term of art that inherently implies a shifted burden of proof. And this court noted in Spicer versus Randall, as cited in our record in Armstrong versus...
Stop just a second. On what basis are you saying that appeal implies a shifted burden of proof?
Well, that appeal is traditionally used in a court setting. When there is an appeal, there is a shifted burden of proof, such as Armstrong versus Manzo referenced the fact that...
What about a de novo trial?
Well,
de novo trial, the burden stays the same.
Absolutely, Your Honor, but they didn't call it a de novo trial.
Did they need to call it by that name?
Your Honor, within the facts, there is nothing that indicates that it was a de novo trial.
Is there anything in the facts that says that they shifted the burden to her at the formal hearing?
Not explicitly, Your Honor. However, even if the burden of proof...
Isn't a de novo trial merely by the fact that she got to call witnesses, cross-examine, bring in her own witnesses? That's a de novo trial.
Not necessarily, Your Honor, because it was trialed by the same board who had already convicted her. In this court held in Pickering versus State Board of Education, that using the same group to do the first hearing and the appeal had, as this court noted, obvious constitutional defects.
But you're suggesting then that a court couldn't remand a case and the case could be reheard by the same judge?
Not at all, Your Honor. Judges are given special legal training, but we'd like this court to reference the fact that this court would never remand a case to a jury. And this is a group of university administrators who are in no way like judges. They do not have the extensive legal training.
Well, it could be sent back down for new trial.
Absolutely, Your Honor, and if this case was remanded, that would be a legitimate provision of Ms. Somerville's due process rights. And Spicer versus Randall emphasized the importance of the burden of proof, so petitioner asked the court to protect its citizens from arbitrary infringements upon their rights and find in favor of Ms. Andrea Somerville in the case at bar.
Why didn't the university, one more question, why didn't the university have the right to discipline her based on the president's broad discretion? She was speaking as a student ambassador. Wasn't she speaking essentially as a public employee when she was making the remarks she was making?
Well, Your Honor, presidents are given broad discretion in their hiring and firing practices. We can look to the fact that she was hired at the sole discretion of Mr. Nolf and the ambassadorial, and maintaining the ambassadorial spirit of optimism and goodwill. And if we look to the case of...
And if she didn't do that, didn't he have the right to dismiss her from the position?
Well, Your Honor, in this case, we do not contend that that is the most important issue in the case at bar. What's most important is that she clearly had her due process rights violated by the board in this case.
Thank you. Thank you very much.
Just had to get that last one.
Mr. Grano, please. Go ahead.
Mr. Chief Justice, and may it please the court. My name is Aidan Grano, and along with my co-counsel Rachel Heflin, I represent Olympus State University and Mr. William Denoff as president. I will demonstrate that Olympus State University enacted its constitutionally protected powers to enforce reasonable time, place, and manner restrictions on the way speech was conducted on the college campus.
Does the university have a problem by the virtue of the fact that it rescinded its policy shortly after this little thing with Miss Somerville?
No, Your Honor. In fact, it does not. First of all, there is no one before the court today who has standing to argue such an issue, as Ms. Somerville was already punished before the changes in policy was enacted. And second of all, the policy explicitly stated that violations of this policy could result in a temporary suspension until the board was able to meet again to ascertain the appropriateness of its restrictions. The university, opposing counsel attempted to argue that in creating a non-public forum on the rest of campus, that the university was overextending its constitutional powers. However, this is not the case. What the university was doing was using its constitutionally protected power to establish places in which demonstrative speech activity could occur without interfering with the educational functions of the university.
What about the problem with the policy that they were talking about, that they were trying to restrict the content of the speech by virtue of this policy of maintaining a positive relationship with ROTC and the military?
Yes, Your Honor, that is the only phrase in the policy that expresses a point of view. And in Windbar versus Vincent, this court made it very clear that when the state is the speaker, the state is perfectly within its powers to articulate an intent and a point of view that it wishes to advocate.
But what happened was that Ms. Somerville was disciplined for actually speaking out against that policy, right?
Respectfully, Your Honor, Ms. Somerville was disciplined for two separate and distinct reasons. The first was that she was likely to impede access to a campus facility, and the second one was that she was jeopardizing relationships with the ROTC and military
Well,
base.
the officer said it's kind of a conclusion that she's likely to impede access to a facility. There's no facts on the record that I could see that actually showed that she was impeding access, were there? Wasn't the officer kind of jumping to conclusions a little bit there?
Your Honor, I don't believe I would characterize it as jumping to conclusions. As a security officer of the university, it is Officer Ide's job and responsibility to detect what he considers to be something that is likely to cause a disruption on
But
campus.
he only came over to this group because they were holding up anti-ROTC signs. They were holding up anti-fur signs. He wouldn't even bother looking at them.
Respectfully, Your Honor, the record offers us no indication of why Mr. Officer Ide was there in the first place. It simply offers the fact that he told Ms. Somerville that she was...
You're not contending that he was there because he was called because it had gotten unruly or disruptive, are you?
No, Your Honor, we're just contending that those facts are outside of our record, and therefore there's no reason to know why he was there. However, even if Officer Ide was simply walking by and noticed that Ms. Somerville was likely to impede access to a campus facility, he was within his rights and his duty as a security officer.
But if he thought that, then why then did he later call this situation to be under control and it not to be something that would be fearful for the university?
Yes, Your Honor. The only distinction that Officer Ide made was that while it was orderly, it was also likely to impede access to a campus facility. And there is a distinction between something that can be orderly and an impediment.
Based on whose opinion?
On his, Your Honor. If we look to the court case of Tinker versus Des Moines, the court there said that when school officials are regulating conduct in schools, they have jurisdiction to make a, quote, reasonable forecast of disruption. And if they can do so and make that reasonable forecast, then they are constitutionally within their rights
What
to
was the
restrict
basis of making a reasonable forecast here?
Your Honor, the reasonable forecast was in the past, many of these protests had become disruptive and jeopardized.
Those previous protests were civil rights. Isn't that a totally different can of worms?
Respectfully, Your Honor, the policy itself is directed toward demonstrative speech. And in the past, many of these demonstrative protests had caused trouble by being held near educational facilities, in classrooms, and the administration building, and causing disruptions.
So these people now, based on their opinion, are being reprimanded based on things that have happened in the past?
Your Honor, the university is intending no content discrimination whatsoever. The actual words of the policy, beginning in the restrictions in point 3, are specifically targeting demonstrative speech without regard to content. Points 1 and 2 of the freedom of expression policy talk to the government's intent, and Widmar made it very clear that where the government has an intent, it is perfectly allowed to advocate a particular side of an issue.
Why designate these zones, though? And specifically, why designate a zone that takes students away from the administration building, which is who they want to direct their message to in the first place?
Your Honor, the freedom of speech zones were created centrally on the college campus and in the places of high student traffic. In fact, Ms.
But
Somerville's...
they can reach students, but they can't reach President Denolf, correct?
Respectfully, Your Honor, Ms. Somerville doesn't have a constitutional right to reach Mr. Denolf. The court in Widmar versus Vincent made it very clear that schools were not constitutionally obligated to permit universal access to all facilities at all times. These protests had in the past disrupted the operations of the administration building, and the court has always held that where the disruptions are physically hampering the administration from doing their job, that their regulations are constitutionally protectable.
So why did the free speech zone, why was it located there if it was going to be in a location that may be disruptive? Why did the university choose that area?
Respectfully, Your Honor, these areas were in high traffic areas near the cafeteria and the student union building where most students traveled. They were putting them centrally located. The policy itself does not give explicit boundaries or square acreage for the zone's creation. In fact, the wording of the policy seems to suggest that Ms. Somerville could be standing in front of the doors to the cafeteria and still be within the free speech zones. It's not a stretch to assume that the university knew that there would be a potential for an impediment to access, simply because point 6 of the freedom of expression policy makes it very clear that that impediment of access to campus facilities was a primary reason that this was an additional restriction imposed in the freedom of expression policy. The university was well aware that someone could be protesting in this free speech zone and still be impeding access to a campus facility.
But nowhere in the record does the officer indicate the impediment to access issue. I mean, as I read the record, he indicates that his attention was drawn because it was an anti-ROTC protest, and then only after he asked her to leave and she refused did he charge her with violating the policy.
Your Honor, when Officer Ide asked Ms. Somerville to leave, he did so because he said she was, quote, in violation of the freedom of expression policy. He did not offer, that we can see in the record, which specific reason that he later included in his report as the primary justification for this. If we look to this court's precedent in Texas versus Johnson, the court said that disruptive speech was a potential for the government to regulate, but that when it was doing so in a quintessentially public forum, not in the type of forum such as a college campus, but when it was in a quintessentially public forum, the standard was that of the Brandenburg versus Ohio test, which opposing counsel articulated earlier. However, another facet of the Brandenburg versus Ohio test was that the speech could be likely to incite immediate lawless action. In Brandenburg versus Ohio, the court upheld the likelihood standard, not necessarily that the action have already commenced.
Was there something in the record, Counselor, that would have led the university administration to believe that ROT demonstrations in particular would result in disruptive activities?
Your Honor, the policy itself does not target the ROTC. The only demonstration we have in the record is President Denolf's evaluation that the ROTC has been an issue that perennially stirred up trouble.
And what was the basis for that? That's what I'm asking you.
Your Honor, we don't have any additional facts to substantiate that. However, the policy itself does not even target ROTC speech. All it does is limit the place in which demonstrative speech activity may take place and limit the manner in which it may do so, saying that students may not impede access to campus facilities. Additionally, the court's test from United States versus O'Brien, as cited in Texas versus Johnson, says that when there is a government policy that is directed at a non-expression-based conduct, that any incidental restrictions on free speech are justified under the reasonableness standard.
Can you address for a moment the fact that on the other issue that Ms. Somerville was let go from her ambassador positions because she was talking on her cell phone to her professor?
Yes, Your Honor. That one fact is the only fact within our record that has been disputed by petitioner in the case of Barr. There's been no dispute that Ms. Somerville's articulation of her views in the administration building or her improper use of the bulletin board was incorrect. And Garcetti versus Sobalos is instructive in that it says one instance of unprotected conduct is not immunized by 6 or 7 conducts in which the constitutional designation is nebulous. In this case, all President Denolf needed to fire Ms. Somerville was her one improper use of the bulletin board.
But that's not what he gave as the reason for dismissing her.
Your Honor, the reason he gave was based on her disruptive speech about the ROTC, and that was, in fact, the reason that she used the bulletin board.
Which was incorrect. He got misinformation.
Respectfully, Your Honor, his misinformation was limited to the telephone call and not to the administration bulletin board. The administration bulletin board...
But it's not that she's not allowed to post there. You're just saying she needs pre-permission. So, I mean, isn't that just semantics? She could have asked the president first and posted, and then there'd be no issue?
No, Your Honor, it is a key distinction because the administration bulletin board... I'm sorry, may I answer the question? The administration bulletin board is reserved for administrative policy and positions only, and Ms. Somerville posted her own private opinions on the administration board, which undermine the efficiency of the office in which she was a part. And Garcetti versus Sobalos makes it very clear that that is sufficient justification for the president to fire her.
Thank you very much.
Thank you.
Thank you.
Ms. Heflin.
Mr. Chief Justice, may it please the Court, my name is Rachel Heflin, and I'll be continuing the arguments for the respondent, Olympus State University, and Mr. William Danoff as its president. Your Honors, this Court held in Morrissey v. Brewer, referenced in Matthews v. Eldridge, that the Due Process Clause is flexible and calls for such procedural safeguards as the specific situation
Counsel,
demands.
let's jump right to the time where President Danoff removed her as an ambassador on that thing. Obviously, she didn't have any advance notice of this hearing. It was an impromptu meeting. She only had 10 minutes to present her side of the story. Can you really say she was given due process when her rank as ambassador was at stake here?
Based on the reasonable manager's test from Waters v. Churchill, yes, Your Honor, we can. Waters v. Churchill clarified first that the original requirements of prior notice and a fair hearing can be combined into one, and that the so-called prior notice may occur simultaneously with the hearing.
Well, one of the problems with this whole situation is that, first of all, the president had misinformation. The issue about the bulletin board may be a little bit nebulous. Clearly, she didn't have authority to do that, but the information he got from his secretary overhearing this conversation was misinformation. If you combine that with the fact that she only had 10 minutes to explain her side, the president was tired after a long day, etc., seems to me that she was lacking something as far as due process and being heard on that issue.
Respectfully, Your Honor, respondent would disagree. First of all, the record clarifies that Ms. Somerville's conversation, or supposedly being overheard speaking out negatively against the administration, was in a long historical context of speaking out. In other words, the record clarifies that Secretary Valeri had overheard Ms. Somerville speaking out passionately against ROTC and against administration policies time and time again. And
So you're saying that because she has a long history of speaking out against ROTC, that's enough of a reason to dismiss her as an ambassador?
If, in fact, she was speaking out against administrative policies in her position as a student ambassador, yes, Your Honor, it would.
How are you drawing the distinction between whether or not she's speaking out as an ambassador or she's speaking out just as a student of the campus?
Some of those facts, Your Honor, are not clear. However, the fact that the Secretary herself overheard Ms. Somerville speaking out, and it's reasonable to assume that Ms. Somerville would only be in the administrative building doing administrative purposes or administrative jobs. In other words, if Ms. Valeri overheard Ms. Somerville, it would have been in her capacity as a student ambassador. However, what is more
That's
important...
elite. I mean, you're saying that if she's just in the administration building and on her way out, she's talking on her cell phone, anytime she's in that building, she's there as an administrative?
Not any time, Your Honor, but the fact that Ms. Valeri, according to the counsel, repeatedly, time and time again, instructed Ms. Somerville to lower her voice and to speak more respectfully indicates that the Secretary had numerable instances where Ms. Somerville was not speaking correctly in her position as an ambassador.
The problem I have is the President, Denault, did not say that was the reason that he dismissed her. The only reason he gave her was because of the conversation that Ms. Valeri had reported, which was, in fact, misinformation.
Well, respectfully, Your Honor, the President did not tell Ms. Somerville that he was firing her because of the information that the Secretary fed him regarding that phone call. Looking at the chronology in the record, we find, in fact, that she blatantly misused the bulletin board the very morning before he called her into the office, suggesting...
That was the precipitating factor for the meeting that evening between Danoff and Somerville. The bulletin board wasn't the precipitating reason of the meeting. The reason was because the Secretary told Danoff she's at it again.
Yes, Your Honor. However, as my co-counsel already argued, based on Garcetti versus Sabalos, all the President needs is one valid reason to fire her, and within his discretion, he clearly had that power. Waters versus Churchill clarified, even though it is a plurality opinion, it is still instructive. And Waters versus Churchill clarified that a government employer may reasonably dismiss an employee if they believe, based on, even if the facts are misconstrued, but if they believe that the employee's conduct is a hindrance to the government's purpose.
But wasn't Ms. Somerville's speech in this long historical context you were quoting to us about a current issue of public import rather than policy, administrative policy? In Garcetti, didn't we have an assistant district attorney speaking out, challenging the policy of the district attorney's office? That's not what happened here, was it?
Yes, Your Honor, it was. While we do know that Ms. Somerville held opinions that would have been considered of public concern, such as speaking out against the war in Iraq, we find that, for example, her use of the bulletin board was not to oppose the war in Iraq or matters that would be classified as matters of public concern, but rather to speak out against the school's ROTC program, something that clearly was classified not as public concern, but as an administrative policy. Thus, her speech on that could be taken into account by Mr. Denoff, and she could be reasonably dismissed from her position.
Why not have a hearing on it, though? When you're going to take away her position, which comes with a high degree of positiveness and esteem in the campus community, why not have a hearing on it before doing it?
According to Waters versus Churchill, Your Honor, Mr. William Denoff did give her a hearing.
And I apologize. I mean, why not have a hearing akin to a trial hearing with witnesses and cross-examination and time to prepare your case?
Well, we find that the record indicates that fairness was given in the hearing that Mr. William Denoff gave her. He told her what the secretary said. He gave her the opportunity to clarify the facts, which she did, and his response was basically, you may hold those opinions, but you are not fulfilling the ambassadorial requirements in promoting a spirit of goodwill and optimism. He reached the right conclusion, which, as this court held in Waters versus Churchill, is indicative as to whether or not proper due process procedures were given.
So reaching the right conclusion doesn't matter whether she was given justice or not?
No, Your Honor, it doesn't. But when examining whether or not a government employer has adequately upheld the due process clause, it is a factor to be considered, as this court held in Waters versus Churchill.
I'd like you to move on to the other problem that we have, and that is the due process on the hearing after the demonstration and the police officer coming up. The Petitioner's Counsel says, rightfully so, that she got a hearing with the opportunity to prepare and cross-examine all the good things that go with it. But the problem is the hearing was held by the same body that had already made a finding against her. What's your response to that?
Two responses, Your Honor. First of all, that there's a difference between the requirements that this court has imposed on the judicial sphere and the requirements that this court has held are appropriate within the context of a school. In Goss versus Lopez, this court held that a school principal may act as the witness to a violation of school policy, as the judge, and as the jury. Consequently, school administrative officials cannot be considered biased merely because they consider the same case twice in a row. Second,
But these aren't school administrators that are making these decisions.
Well, Your Honor, we don't know exactly who composed the Student Disciplinary Board, but it would be reasonable to assume that they were school officials in high positions of authority, people who were considered to be fair arbiters and who understood the rules and the violations, therefore. The second response, going back to the Chief Justice's question, is that Ms. Somerville was also given the opportunity to appeal to the Dean of Students. She was basically given a three-tier process. First of all, right after the violation occurred, the Student Disciplinary Board met, found that she was in violation of the Code of Conduct, and punished her. Second, they gave her the opportunity to respond and defend herself, giving her even greater latitude than the court held was necessary in Goss versus Lopez. Goss versus Lopez said that they merely needed to give a fair post-termination hearing, but did not require evidentiary tools such as the ability to bring forth witnesses and cross-examine.
Was the appeal before the dean? The record doesn't tell us what kind of an appeal that was. That wasn't a de novo trial, if you will, was it?
We don't know, Your Honor. That's not clear.
But does that appeal, I guess the record's not totally clear, but does that appeal really rectify whatever deficit was involved if you take the position that the committee had already made it determined, therefore it was improper for it to have the hearing? Would the appeal to the dean rectify that problem?
Yes, Your Honor, it would, because he is a separate arbiter from the panel of individuals who made the first decision.
But the fact that he's separate, Counselor, given the relationship of the dean to the president of the university, what's your basis for persuading us that the dean of students was an impartial arbiter?
That within a reasonable context, in the context of a university and campus, it would be reasonable, Your Honor. Opposing counsel relies on Armstrong versus Manzo. However, the case that was remanded there was remanded back back to the exact same decision makers who were supposedly held to be biased in the first place and ruled against Mr. Armstrong. In this, when we add that fact to the combination of the facts in Goss versus Lopez, we find that it's reasonable we find that the due process given Ms. Somerville was quite reasonable. When she was given the ability to appeal, opposing counsel relied on Goldberg versus Kelly, saying that she basically needed a post-termination hearing. But Matthews versus Eldridge said that Goldberg versus Kelly was the only Supreme Court decision in recent years to hold that a pre-termination decision was necessary. Because of that, we ask the court to affirm the lower court's decision.
Thank you very much. Rebuttal, please.
May it please the Court. I'll be concluding arguments for Ms. Andrea Somerville in the case at bar, first starting with the issue of due process and then moving on to the compelling interest that the school lacked in the First Amendment. Under due process, we are not asking this court to retry the facts of the case to give due process itself. We are asking this court to rule that Ms. Somerville did not receive due process in this case. If we look to the issues raised by opposing counsel about the board's decision, they first cited Goss versus Lopez and said that in Goss, the principal just had to sit down with the students. But, Your Honor, we would point this court to the fact that in Goss, it explicitly said that that only would apply in 10-day suspensions or less. If there was anything above that, that required more due process. And, Your Honor, in this case, Ms. Somerville was threatened with expulsion. Additionally, Your Honor, the facts that were referenced.
When you say threatened, are you saying threatened because somebody says you might get expelled, or just because that was a potential penalty for violating the code?
At any point throughout the entire process, Ms. Somerville could have been given expulsion as her punishment. She deserves the type of due process that would protect her from arbitrary infringement upon that right.
And I just want you to clarify, are you saying that she got no due process, or what she got wasn't adequate when she was facing expulsion?
Your Honor, we're not saying she got no due process whatsoever. What we are saying is that providing of sufficient due process, according to this court, requires notice, hearing, and impartial adjudicator, and she didn't receive the last requirement. The opposing counsel referenced the third appeal, but, Your Honors, I'd just like to point out the fact that it doesn't matter how many appeals Ms. Somerville could have. She could have 1,000,000 appeals.
Are there any cases, though, that you can point to, and I don't mean to belabor this point, but any cases you can point to that would indicate that the disciplinary committee couldn't be an impartial adjudicator because it had heard it once before?
Absolutely, Your Honor. Pickering versus State Board of Education explicitly noted the obvious constitutional defect with having the same board try the first hearing and an appeal. But moving on to the issue of the First Amendment, there is no compelling interest presented for the justification of this actual policy. We see there were two justifications supposed, first being disturbance to education, which was explicitly rejected by this court in Tinker versus Des Moines when this court ruled that despite the fact that there was clear disturbance in that instance to the math class, that was insufficient to invoke due process. Additionally, Your Honor, in the case at bar, if we look to the facts, there is no disturbance related to the ROTC. There is absolutely no history of disturbance that we have within the record that relates to the topic of the ROTC. This is pure speculation.
But the officer said that he thought there was likely to impede access to the campus facility and jeopardize relations with the military base. Isn't his opinion worth something?
Your Honor, there are two important responses to that. First is that the officer noted that this was an orderly protest, and if an orderly protest may impede access in a place where the university designates, that is a problem with the university's designation. We ask the court to rule in favor of Andrea Somerville.
Thank you very much.
Thank you.
Well, did you guys enjoy that? Yes. We did not enjoy scoring it. Literally. I know there are no further rounds, but I want to give the justices a time to, if they want to say anything, comments or anything like that, I give you guys a chance to say anything you want to say.
Just again,
Speak in the microphone, Jim.
he said that it was very difficult to score it, and the impressions we got, we didn't have an unfavorable impression in any specific area for any of the four of you, which is part of the reason why it's difficult. A few things stand out. Obviously, we think that the way the cases are set up, the respondent obviously has a very difficult argument, particularly in the area of content neutrality and and viewpoint discrimination. Therefore, Aidan, you got the short straw on that argument, and I think we worked you over pretty good. And we thought that you held up, you maintained a very good equanimity while you were getting filleted by 3 or 4 of us, particularly responses to, citing the Tinker case with regard to the campus officer, citing O'Brien on the question about whether or not the petitioners had a right to address the president, through the administration building, those types of things. Very good responses. I thought both sides did very well under very difficult questioning. What I think we're most impressed with is your poise and your unflappability. And you don't see that very often in real court, particularly in appellate court arguments that I'm sure some of us have had an opportunity to witness or participate in. And the fact that you folks are doing it not as law students, but as college students, I think is almost mind-boggling to those of us who have been around for a while. So what I want to say is nobody really lost this round. It's what we wish we could decide for both of you, and because all of you, Rachel also, I should mention again, you got hit pretty hard, and you managed to do well. Joseph, I thought, again, your knowledge and also your equanimity in responding in these cases was very impressive, as it was in the last round. So I just wanted to say, all of you, great job.
Great job. Anybody else want to say anything? No? Okay. At this level, when you got the last 2 teams of 56 teams, the one thing that really stuck out in my mind, both teams did this, was you picked up on what the other side had said, and then you addressed something the other side had said. So not only are you sitting there nervous, waiting to argue your points, but you're listening to the other side, and you're coming up and you're addressing that to the court. We did not score numbers. I suspect that if we did, out of all 5 of us, the difference would have been 1 or 2 points. It was that close. And we went for the respondents in this case. Congratulations.
We're going to do the awards in just 1 minute, but before we do, I want to give special thanks to our judges here. We had 72 different attorneys and judges here over the last 2 days, which is a really amazing turnout and support. And we could not have done that without the support of the North Worcester County Bar Association, and of course our Chief Justice here, Chris Lund in particular, who just does an amazing and untiring job in recruiting people for this. So again, thank you very much for all your help during this process.
You're welcome.
Okay, if we can have our runners up. And then the 2008 regional champions, Rachel Hefflin, David Moot. And I should mention to you that Rachel is the first repeat champion in the history of this event, so that's really quite an accomplishment too. Don't go anywhere. Get the close one.
Punching a little bit closer. Oh, yeah.